I'll be briefly discussing the case Gogoro Inc. versus the Controller Patents and Designs and another. So the facts of the case as follows. This particular case relates to an appeal challenging the order passed by the Assistant Controller of Patents dated 8th August 2021, rejecting the appellant's patent application for an invention titled Apparatus Method, an article for authentication, security, and control of power storage devices such as batteries. The appeal was filed under Section 117A of the Patents Act. The particular application was refused on the ground that Section 21J of the Patents Act 1970 had not been complied with. The timeline of the events are as follows. The patent application was filed as a PCT application on 26 July 2012, claiming priority from US patent application, which was dated 26 July 2011. The Indian patent application was subsequently filed on 20th February 2014. A request for examination for the application was filed by the appellant under Rule 24B of the Patent Rules on 30th October 2014, following which an FER was issued by the Patent Office on 20th August 2018, raising grounds of lack of novelty, inventive step, and citing prior arts D1 and D2, as well as non-patentability under Section 3K of the Act. A reply to the FER was filed by the appellant on 20th February 2019. Subsequently, a hearing was conducted on 16th December 2020, and the written submissions for the aforementioned hearing were submitted on 31st December 2020 with an amended set of claims were filed with the Patent Office. In the PCT Indian application, one of the claims from the PCT application was deleted and the same was filed. Now, in the FER, in D1, some features of D1 were cited, including the method claims, while in D2 only some features were cited and no citation relating to method claims was given in the FER, which means that D1 and D2 did not fairly explain how inventive step or novelty was lacking. Now, three issues were raised. There is lack of clarity in the impugned order as to whether the application was rejected on grounds of lack of novelty or whether on grounds of lack of inventive step. The second issue was that three prior arts, D1, D2, and D3 were cited in the order. However, the order only discussed D3. Third issue was, which is the issue which I'll be concentrating more on, is lack of reasoning and elaboration on why there is lack of inventive step in the invention in question with respect to the prior art D3. Now coming to the issue one, rejection on grounds of lack of novelty or inventive step, the court observed that on perusal of the order, it seems that there is a confusion as to whether the application was rejected for lack of novelty or for inventive step. Now, based on the written submissions made before the court and the statement made by the Patent Office, it was made clear that the objection relating to novelty was dropped, and therefore only the surviving objection in respect to lack of inventive step was there. Now, coming to issue two, three prior arts, D1, D2, and D3 were cited, and only D3 was considered. In regards to that, in the FER, prior arts D1 and D, the court observed that in the FER, prior arts D1 and D2, and the manner in which they support the lack of inventive step is slightly elaborated. Insofar as the impugned order, only prior art seems to have been considered. So in the order against which the appeal was filed, it did not discuss anything about D1 and D2. With regard to issue 3, which is related to lack of reasoning and elaboration on why there is lack of inventive step, the court observed the following, that while arriving at the conclusion that there is lack of inventive step, there is no elaborations or reasons given by the controller for the said finding at all. For the controller to find lack of inventive step, some discussion was required as to how the prior arts render the subject invention obvious to a person skilled in the art. So this point that the controller to find lack of inventive steps, some discussion was required, is an important point which was raised in this particular decision. The court cited its decision in the case of Agribot International LLC versus Deputy Controller of Patents and Designs. And it said that while rejecting an application for lack of inventive step, discussion on prior art, the subject invention, and manner in which the subject invention would be obvious to a person skilled in the art is mandatory. So the word mandatory is important here. And merely arriving at a bare conclusion that the subject invention lacks inventive step would be contrary to section 2(1)(j) of the Act itself. The judgment further cited some of the paragraphs of the aforementioned judgment, and I'll just briefly read the paragraphs which are relevant. In the opinion of this court, while rejecting an invention for lack of inventive step, the controller has to consider three elements. First is the invention disclosed in the prior art, the invention disclosed in the application under consideration, and the manner in which subject invention would be obvious to a person skilled in the art. The second important paragraph was, without a discussion on these three elements, arriving at a bare conclusion that the subject invention is lacking inventive step would not be permissible unless it is a case where the same is absolutely clear. Section 2(1)(j) of the Act defines inventive step as under. Inventive step means a feature of an invention that involves technical advance. I'm emphasizing on this particular point as compared to the existing knowledge or having economic significance of both, and makes the invention not obvious to a person skilled in the art. So comparing to the existing knowledge and explaining as to why it is not obvious to a person skilled in the art is an important ingredient of section 2(1)(j). Thus, the controller has to analyze as to what is the existing knowledge and how the person skilled in the art would move from the existing knowledge to the subject invention captured in the application under consideration. Without such an analysis, the rejection of the patent application under section 2(1)(j) of the Act would be provision itself. Now, discussing the following points for analysis. The controller should provide with adequate reasoning and elaboration on why cited prior art is relevant for rejecting an application for lack of inventive step. It is mandatory to elaborate upon invention disclosed in prior art, the subject invention, and manner in which the subject invention would be obvious to a person skilled in the art. So these three ingredients are important when the controller is providing reasoning as to related to lack of inventive step. Now, if the controller is citing multiple prior arts, then there is a requirement to provide reasoning for lack of inventive step in respect of all the cited prior arts. So in this particular order, only D3 was provided some with some discussion on D3 was given, but it seems from the order that D1 and D2 were also mandatory to be discussed in the order. Application restored to its original position, which means that since the application was at examination stage before the impugned order was passed, after the submission of the amended claims, the application will be re-examined. The use of the phrase may be expeditiously examined by the patent office is permissive and lacks the requirement of obligation, which means that it is not mandatory that the patent office need to examine the application expeditiously. Since the application was filed in 2014, it is possible that again there might be a delay. Now, coming to the last point of analysis, there is no discussion on the point raised by the appellant that the independent method claims are also not considered by the controller, and there is no clarity in the impugned order as to which of the claims lack inventive steps. So, although there were product and process claim, method claims both, the controller mostly discussed on the product claim itself, and there was a lack of explanation regards to method claims, and this particular order is not very elaborative as to what happens for an independent method claim as well. Thank you.
Thank you very much, Aditi. In fact, this is a judgment that reiterates the fact that the decisions of the patent office have to be reasoned, and especially with respect to inventive step analysis, the decisions have to clearly explain why a particular prior art reference is relevant, how these prior art references when combined would make an invention obvious, and how that obviousness would be from the perspective of a person skilled in the art. More often than not, we see that several decisions that are given by the patent office are quite conclusory, and they lack a reasoned analysis with respect to why an invention is not patentable under a given provision. This case reiterates the need for a reasoned analysis and emphasizes the fact that these decisions can be challenged if they're given in a conclusory manner.